letting participants in here. I usually wait till 1. Oh, you wait till 1, okay, I was like, do you only have 18? Where is everybody? Well, so far we have 5. Oh,
Everyone in?
There's 8 so far.
Well, it appears there's only 8 people attending right now, so I'm gonna let it pause a little longer to see if some other people show up. Is Hatsina here yet? No.
I know we had more than 8 people RSVP, yes. There were a couple of people that said that they couldn't make it.
There's some. Mhm.
Hasina, I just wanted, in case I forget to say this later, I did go through and try to find places where we were requiring things to be posted to a website or something like that, and tried to add specific language for, those small districts, and a lot of the districts you represent obviously don't have that capability. So I tried to put in language that would address their situations in each of those places. But I would simply ask you if you, when you're going through the rules, see any additional places where we need that sort of language, just let me know, okay?
Hi, and good afternoon. My name is Jennifer Olson. I actually work with Hasina. She was unable to make it today, but I will pass that along to her.
Okay, thank you. How are we doing?
12 minutes.
Let's give it a couple more minutes.
Did everyone get their copies of the proposed rules? Seeing nods, okay. That's good.
Hi, this is Chris Wright. I don't know about everybody else, but I had a heck of a time getting actually in. I have 7 devices and only one of them is able to pull up the Zoom meeting.
Sorry that
And
happened, Chris.
so I'm not sure if other people might be having problems. Just throwing that out there.
Well, hopefully it's not a systemic issue, but we've had them obviously in this process. So like I said, I'll give probably an extra 3 more minutes or so to see if some others can join. For the person sitting in for Hasina, can you put your name in the chat? That way we'll make sure we're spelling it right in our records.
Yes, no problem.
Thank you, Jennifer. Well, it's 1:08 and I think we should begin. And if people are able to join in, all the better. Thank you all for coming again to our 5th RAC meeting. We will begin with a roll call. So Casey?
Okay, if you can just indicate that you're present by stating that you're present, that would be great. Adam Abplanel. Beth Woodard. Brenda Sanchez. Carolyn Shields. Courtney Sneed. Chris O'Grady.
Present.
Ragav Shan. Gabe Shepard.
Here.
Jennifer Olson.
Here.
Jeb Bladine. Joe Barker. Corey Tate.
Yes, here.
Chris Wright.
Here.
Liz Fouther Branch. Mallory Roberts. Matthew Call.
Here.
Michelle Smith, Nancy Sandoval,
Here.
Rob Bovet,
Present.
Sarah Savala,
Present.
Scott Winkles,
Here.
Sherry Kinsey,
She is here in chat, but her mic is having problems.
okay, great, thank you. And Therese Holstrom
Here.
and Tiffany Johnson.
Is there anyone who is present whose name didn't get called? Okay, well,
Someone joining back. Oh, was that wrong? Working.
hold on a second.
They don't match any of my numbers, but
You might admit them and then ask them to confirm who they are.
should be in there.
And this is someone joining by phone?
Mhm.
What's the number?
The last four are 4878.
Someone joining by phone and the last four are 4878. Could you identify yourself?
Hi, good afternoon. This is Beth Woodard from the City of Portland. I just needed to be mobile today.
Okay, that's fine. We'll mark you as here.
Thank you.
Okay, so all of you were provided with a clean copy of the compiled rules. Basically considered the comments in the last 3 meetings. Worked on changing some language in the rules. Had many discussions about the proposed language and some of the issues all of you have raised and revisions with our DOJ counsel. And so this is where we have landed as the compiled set of rules. So we are going to jump in and start with definitions. And so Casey, if you want to start with rule number 199-050-0005.
Sure. 199-050-0005 definitions. The following definitions are provided for words or terms as they are used in ORS 192.610 to ORS 192.705 and as they are used in these rules. Sub 1. Communicate means the act of a person expressing or transmitting information to another person through verbal, written, or electronic means. Sub 2. Communication means the expression or transmission of information from one person to another through verbal, written, or electronic means. Sub 3. Decision, deliberation, executive session, governing body, meeting, and public body have the meaning given those terms in ORS 192.610. Sub 4, decision-making process means the process of a governing body engages in to make a decision, such as A, identifying or selecting the nature of the decision to be made, B, gathering information related to the decision to be made, C, identifying and assessing alternatives, D, weighing evidence, E, choosing among alternatives, and F, making a decision. Sub 5, deliberate means any discussion or communication that occurs as part of a decision-making process. Sub 6, discussion means the consideration or debate of a question. Sub 7, Intermediary means a person who is used to facilitate communications among members of a governing body about a matter subject to deliberation or decision by the governing body by sharing information received from a member or members of the governing body with other members of the governing body. The term intermediary can include a member of the governing body. Sub 8, public meetings law means ORS 192.610 to 192.705. Sub 9, quorum means the minimum number of members of a governing body that shall be present for the governing body to legally transact business. In the absence of a statute, ordinance, rule, charter, or other enactment specifically establishing the number of members constituting a quorum is a majority of the voting members of the governing body. Sub 10, serial electronic written communications means a series of successive or sequential discussions or communications between members of a governing body using writing or written electronic means, including emails, texts, social media, and other electronic applications that communicate the written word.
Go ahead, Rob.
Believe it or not, I just have two very minor things, almost grammar. I'm not sure we need sub 5, since we've essentially already referred to the definition of deliberation in the statute, and deliberate and deliberate have two meanings, and it basically just repeats the statute. I think you can safely get rid of 5, just my opinion. And then on quorum, the word shall in the first sentence, which is the second line down from that definition on my print, I think grammatically that would be better as a must rather than a shall, because of the tense it's being used in. But again, two minor things compared to what I usually comment on. So thank you.
Yes. Okay. Sorry. So let me address those two. The shall, I had a long discussion of must versus shall with DOJ, and with them saying I had to turn all my musts into shalls. So that's their style guide.
And let me just say, as you know, having worked in legislative council, I get that when the context is correct. And if you'd used a may or a may not,
Yeah.
I would have been. But I think the context here, must and shall, is synonymous. I just think the context here requires it be a must because it's a definition. But if you want to keep shall, I'm not going to pester you about it at all. I just don't think it reads quite right.
And then the number 5 was also sort of a DOJ insistence. I see your point on the fact that deliberation is in the statute. They want this included. So that's where we were at. Matthew.
Oh, thank you. Just a couple questions for under 4 and decision-making process. I'm under D and E are a little strange to me. If you're identifying, assessing alternatives, and then weighing evidence, and I'm not sure you're always going to have what evidence would be, or if you're always going to be having evidence. And if you are, it seems like you're assessing the alternatives in that. And then choosing among alternatives seems to be the same as making a decision. And then under 6 for discussion, the consideration or debate of a question. And I was just, nothing in here describes what a question is. So if there's a different reference, if it's the consideration of a decision or something else, but that didn't seem to line up with anything else.
Perfect. Great. Therese.
So Rob covered 2 of the edits I had, and Matthew just covered my 3rd. And I just wanted to comment on section 6 discussion, that I agree that the word question in there is, it could be confusing, because to me, it seems that a discussion could be related to like a motion, which isn't necessarily a question. So I would just second that, I think it would be good to maybe change that word or explain it further.
I agree. I will work on that one. Nancy.
Can we add body language or gesture to communicate? I think everybody would understand if we flip the bird what that meant, or if we roll our eyes, the understanding to that. And it is, body language is 70% of the way that we communicate as humans. So I think it would be a good thing to add gestures or body language. Not only that, it allows people that use sign to communicate to also incorporate that as well.
We'll look into it. I mean, I don't disagree with you that certainly in terms of accessibility, we want that. People who sign communication is still communication. The body language itself can potentially be problematic because while everyone communicates via body language, is that it may not be the intent to communicate versus body language. It may not be body language. It may not be tied to what is under consideration. So I will think about that and discuss it with my DOJ counsel. I think it's potentially difficult to add body language in. Scott.
Well, if we do add eye rolls in, I'll have to declare a conflict of interest. So I do sit on a board, and I'm going to be up in front of you all the time. I'm sorry, it's not my best feature. But if we could revisit with DOJ on 5, because I think deliberate means, I think it actually creates challenges, because there are communications that are defined elsewhere in the statute, like fact finding, that could create, I think, some disagreement in other parts of this OAR. So if they can, and I think if it stays in, you would need to say what deliberate isn't, as well, which I think is just adding additional work. That's my take.
I think the key component to that, Scott, is that deliberate is done intentionally.
Yeah, but that's not what it says. It means any that occurs as part, I mean, if we want to go, I've been advocating for a knowing and intentional standard for a while, so I'm fine with throwing that in there.
I will revisit that one with DOJ, since it was their suggestion. Gabe.
Yeah, I just wanted to support Nancy's discussion about body language. I've had a counselor flip another one off in a meeting before, and people not, when there's a question before the council and people are voting, I've seen counselors nod or at another counselor to let them know to vote yes on this one, or like shake their head slightly to vote no on something, trying to communicate to another counselor how they should vote. So it is something that comes up in city meetings occasionally.
Chris, right.
And I would concur on that. I've been in meetings where we all nod, and that is literally out loud said. I see all the commissioners nodding yes. So that may be an issue. And if it's not allowed that way, it should be in the public meeting laws, so commissions don't do that. Thank you.
Okay. Do we have anyone else? I'm Sherry, and Sherry Kinsey's here. She has mic problems. Sherry, if you have any questions or comments that you want to add, feel free to add them to the chat and we will read them aloud. Okay, are there any other comments on the definitions? Matthew.
Yeah, thanks, Susan. On 10, for serial electronic communications, the third line, where it talks about governing body using writing or written electronic means. What's meant by writing?
Yeah, that could be simplified.
Okay. Or
I'll
just
take
simply
care of
using
that.
the same phrase, but using
Yeah.
written means to keep the consistency there.
I think it may be somewhere in a statute, but I'll see if I can. I agree about keeping it consistent. Okay, anything else on the definitions? Okay, then we will move on. Casey.
199-050-0010, governing bodies subject to the Public Meetings Law. Sub 1, the Public Meetings Law applies to the following types of governing bodies. Sub A, decision-making bodies. The decision-making body is a body with the authority to make decisions for the public body on policy or administration. A body meets the standard if its decision-making authority includes the power to exercise governmental power and act on behalf of the public body. Sub B, advisory bodies. An advisory body is a body with authority to make recommendations to another governing body on policy or administration. Sub 2, Public Meetings Law does not apply to the following types of bodies. Sub A, fact gathering. Bodies with authority only to gather and provide factual information to a governing body and which do not have the authority to make decisions or recommendations. A body with authority to determine facts or to make a recommendation about competing factual information is not subject to this exception. Sub B, advising individual public officials. Bodies with authority to make recommendations to an individual public official, provided the individual public official has the authority to act on the body's recommendations and is not required to pass the body's recommendations on unchanged to another governing body. Sub C, certain multi-jurisdiction bodies. Multi-jurisdictional bodies whose organ members do not constitute a majority of the governing body's voting members.
Comments or questions? I'm gonna think the heat's getting to all of you. Okay. Nobody has any suggestions or comments on?
My only suggestion, Susan, is for consistency purposes on 0005, you have everything in quotation marks, and down below you have everything like with ending in period. So like you have decision-making bodies, period, instead of in quotation marks. So just for consistency purpose, pick one or the other.
Yeah.
Well, except that 0005 are definitions and 0010 are more I would call headers.
Yeah, I think there will be probably some additional work that we have to do to make clean up formatting and meet the sort of internal LC stuff. Trees.
Yeah, the description of the fact gathering body exception, that last part of that, and this is 2A of 0010. The last part, it's where it says, you know, a body with authority to determine facts or to make a recommendation about competing factual information is not subject to this exception. I wonder, I think it could be clearer if that stated that basically a body with the authority to determine facts or make a recommendation about competing factual information is an advisory body and not a fact gathering body. Is that, I mean, that's how I think it's intended to read. But maybe I'm misreading it.
No, I think you are right. It is sometimes the examples of when is a body that simply collects factual information for another governing body and doesn't sort of make recommendations or select what information they get or don't get. When you read the AG manual, it talks about in defining sort of decision-making bodies and advisory bodies, it gives sort of that example of a body that only collects information and presents the information without anything more would not be a governing body. And so it's trying to sort of thread that needle, but I think your suggestion of clarifying that what we mean here is that if a body is determining facts and making recommendations, then it is an advisory body up above and not simply a fact gathering body. So I will play with that some more.
Okay, thanks.
Any other comments or suggestions?
No, that's something similar I was also concerned about. She covered it. Thank you.
Good. We have nothing more on this. We will forge ahead to the next rule.
199-050-0015, meetings subject to the public meetings law. Sub 1, the purpose of this rule is to clarify what meetings of a governing body are subject to the public meetings law. Sub 2, the public meetings law applies to the following types of meetings. A, regular meetings. B, special meetings. C, emergency meetings. D, executive sessions, whether convened separately or as part of a regular, special, or emergency meeting. And E, meetings held for the purpose of either presenting information to the governing body to prepare the governing body for a regular or special meeting, or to allow the governing body to engage in preliminary discussions or deliberations. These meetings are often called work sessions or workshop meetings. Sub 3, the public meetings law does not apply to A, on-site inspections of projects or programs, provided the members of the governing body do not engage in deliberations or decisions on matters that could reasonably be foreseen to come before the governing body. B, the attendance of members of a governing body at any national, regional, or state association to which the public body or the members belong, provided the members of the governing body do not engage in deliberations or decisions on matters that could reasonably be foreseen to come before the governing body. C, communications between or among members of a governing body, including communications of a quorum of members that are A, purely factual or educational in nature and that convey no deliberation or decision on any matter that might reasonably come before the governing body. B, not related to any matter that at any time could reasonably be foreseen to come before the governing body for deliberation and decision. Or C, non-substantive in nature, such as communication relating to scheduling, leaves of absence, and other similar matters. Sub D, any matters listed in ORS 192.690. Sub 4, a private meeting where a quorum of a governing body engages in discussions or communications that are part of the governing body's decision-making process, or where the governing body makes a decision within the authority of the governing body, violates the public meetings law.
Scott.
Could you scroll back up to top? Yeah, so A, this is kind of what I was getting at on that number 5 deliberate definition, is that you have this section that defines any communication as deliberation, but then this other piece that says on-site inspections of projects, and that's going to be part of the decision-making process. And I just feel like it's going to be challenging. That conflict is going to be challenging as this goes forward and we all start dealing with complaints from the public. That just kind of articulates, just demonstrates pretty clearly what my concern was with that deliberate definition being in there. In my mind, these two things just don't agree.
Okay. All right. Well, I may come back to you, Scott. Hold on. Go ahead, Rob.
Well, I agree with Scott. I think that particular sub-issue is more a function of the statute as it exists today. I'm not sure that this makes it better or worse. You might be able to make it better through rule, but I have to think on that. But if you could scroll up a little further, I just wanted to note something. And E, no, you went past there. Just scroll down a little bit. There you go, E. I really like the thing in brackets because it removes our previous attempt to define work session. But I just should note, kind of for the record, if nothing else, that what you've defined here is actually what our legislature will call an informational session or an informational meeting. And just again to note, some bodies, including our legislature, refer to a work session as when they actually take action. I know that's reverse and upside down, but so I really do like the fact that you have put this in brackets and really made it an example rather than a definition. So I just wanted to note that for folks, because there might be folks that read that definition of E and say, well, that's not what we do. And keep in mind, it's in brackets. It's just an example.
I appreciate, went back and forth, obviously. I think most of the entities I've dealt with in the past have called them work sessions, but I also recognize that there may be some that don't. I have seen minutes where they're called workshops. I've seen cases where they were simply called informational sessions, and given all of that in our prior discussion, this was my best solution to kind of try not to define it. They're meetings regardless, as are executive sessions. It's a regular, special, or emergency meeting, but it helps to kind of clarify for people sometimes. There are a number of entities that seem to think that because they're calling it a work session or because it's an executive session, that somehow it's not subject to public meetings law, that they don't actually have to have minutes or a recording. So I think it's helpful to have it in here, and I appreciate your noticing that hopefully this solves some of the definitional problem. Chris.
I'm wondering if sorry, yes, Chris, right? If a public meeting is held on site where an inspection occurs, then the public meetings law doesn't apply. Does that ever happen in like an emergency situation? Where they bring counselors to an area or a governing body might meet at an inspection site and have the meeting there? Or do they have to hold it in the building where they've normally hold their meetings?
I think it's 6:30. I mean, there are restrictions on where they can hold meetings, primarily just that it needs to be within the jurisdiction, absent certain other exceptions. So if the on-site inspections location was within the jurisdiction, they could notice a public meeting and simply hold one there. I don't know that that's where what we were trying to address. This is more that the statute has that specific exception, saying a meeting is this, a meeting is not this, and it specifically calls out. So the idea is that, they could go and do an inspection of whatever it is. And the fact that they're all there for the inspection does not turn the inspection into a public meeting, assuming that they don't then just show up at whatever the location is and then start talking about public meeting stuff.
Yeah. Okay. And then the number 4, a private meeting where a quorum of governing bodies engages in discussions or communications. Could it be clarified, or is that prohibited after a meeting? Say you go and you've deliberated, right? You've already did the meeting, and then you meet at a later time and then talk about it again. Would that be considered a private meeting after the fact? After a hearing's already been done, or is this prior to any hearing?
It would be both. If the governing body is deliberating or discussing or communicating on a matter subject to the governing body's deliberations, that needs to take place in a public meeting.
Okay. All right, thank you. That clarifies.
So, Scott, I wanted to come back to you if possible, because I want to make sure that I can fully explain what you see as the conflict here to DOJ.
So, sorry.
No, that's okay. So go ahead.
So 5 prohibits any communication that's basically in furtherance of the decision-making process. Do we agree on that? I mean, in the context, it has to be, or
yes,
outside of a public meeting. And then you've got this A, but that decision-making process can include all kinds of other stuff like fact-finding, and you've got these other communications that are listed between or among members of a governing body, including purely factual or educational in nature.
Okay.
And that seems to me that is a communication in furtherance of the decision making. I just think you should have, we're going to define deliberate and prohibit all of those communications, then either you don't need A or you don't need the deliberate definition. It just strikes me as a disagreement.
Yeah. Okay. It makes more sense now. Therese.
Well, I agree and understand Scott's concern, but when I was looking at the definitions before our meeting today, I checked over the definition of deliberation from the statute again, because I was wondering why there was a definition for deliberation, pulled in from the statute that you have in subsection 3 of your definitions. But then there's a separate, in subsection 5, there's a separate definition for deliberate. And I heard your explanation before, but the statutory definition of deliberation does include, communication that is part of a decision-making process. And so I guess I understand Scott's concern that if you add that any communication that is part of a decision-making process, it goes too broad. So I wanted to, but that wasn't my comment that I raised my hand for. I just wanted to add on that since you just discussed it. There's a definition that you have for decision-making process. But I noticed that in 0015, when we're talking about meetings subject to the public meetings law, there's a lot of references to deliberations or decisions, and references to decision, but there's never any reference to that definition included about decision-making process. And I'm not sure, I don't have like a solution to that. I just noticed that there was many references to decision, but not necessarily any reference to those pieces of the decision-making process. And
Yes.
I found it to be a little bit confusing.
Okay, so it is in 015 sub 4. It comes up, communications that are part of the decision-making process. But so I made an effort to try to establish some consistency on the language by going through, and that's why sort of the deliberations or decisions language sort of is repeatedly appearing. I don't know that I could put the decision-making process language into sort of these exceptions in the like 3A, B, or C. But I will kind of continue. If there are specific places where you think the decision or deliberate language gets out of control, because trust me, after messing with these for a long time, it all, after a while, starts to sound alike.
Yeah, I'll think
if there
on
are
it.
specific places, feel free to make a suggestion where instead of phrasing it the way I have, if it would work better to call it part of the decision-making process and be done at that. So
yeah, I'll think about that. And that there might be a way to kind of not be so overbroad, to address Scott's concern, right? Of like any communications, right? We can like curtail it to communications that are part of that decision-making process.
Yeah. Okay. Let's move on to 20.
(199-050-0020) serial communications prohibited. Sub 1, a quorum of the members of a governing body shall not, outside of a meeting conducted in compliance with the public meetings law, use a series of communications of any kind, directly or through intermediaries, for the purpose of deliberating or deciding on any matter that is within the jurisdiction of the governing body. Sub 2, the prohibitions in section 1 apply to using any one or a combination of the following methods of communication. A, in person. B, telephone calls. C, videos, video conferencing, or electronic video applications. D, written communications, including electronic written communications such as email, text, and other electronic applications. E, use of one or more intermediaries to convey information among members. And F, any other means of conveying information.
Scott.
So, and I think I raised this when we were talking about this section originally, but we still have the problem of who commits the violation. And so let's say you have Counselor A who has a conversation, and only this conversation, with Counselor B. A stays silent for the rest of the duration of this example. B then pulls a full quorum. Is the violation on B, or is it on Counselor, or is it on all of them? And that you have this area where A could have no knowledge of the other conduct or any other communication being dragged into a serial quorum is incredibly problematic to us. And I realize I may need a bill to fix that, but you know, I am a lobbyist, so that's certainly something we can look for. But if we can do that in rules to make it very clear as to who is it who commits the violation, that would be very helpful. And this is why I had and will continue to advocate for that intentional and knowing standard, that anyone who, that if you have to actually intend to form a serial quorum or engage in this conduct, as opposed to someone who is just frankly hapless and committed no violation, if that's taken per se by itself. So I don't know what you want to do with that, but it is very concerning to me, and I think you will see. I think you're already seeing it in those cases that are going to refer to you on these on the open meeting violations, where that has happened, where someone who had one conversation, had no knowledge, is now facing an ethics violation. And that's going to be a problem for us.
I understand that. I am struggling to find a way to solve that in the rule, but I'm certainly open to doing so.
Where was
DOJ
on the intentional and knowing?
Yeah. That adding and knowing and intentional into the rule causes a great deal of angst.
And without it, we have a great deal of angst.
Yeah. So, I mean, it may be that really this might be better solved through legislation, through a fix, but is there a way of addressing it without adding the terms knowing and intentional?
I mean, I can come up with some synonyms, but I don't know that DOJ is going to like that anymore. But I think you could say, or there might be another, if I can come up with a way to do that, but it's going to come down to a similar concept phrased a different way, which maybe DOJ will go for. But as this is now, we've got members who have liability for conduct that doesn't really meet, they never intended to violate, or nor would they have had another party not taken a step. That's where this really breaks down, is that they have no control over what somebody else does, and then they've got a violation. It's the same reason you don't take gift cases on in-laws. when an in-law takes a gift. There's no control over what that other person does.
I don't want to get into the very wacky definition of what in-laws count as relatives and which ones don't.
Right. Well, my point is that you typically shy away from cases where the public official really has no lawful control.
Yeah. We will continue to fight. I don't disagree with the concept here, but the dilemma is adding, I would be interested to see, is there a way of maybe clarifying in the rules when maybe it's less about adding the knowing and intentional and more about clarifying when the violation occurs. Like the first two of, say it's a 5-member board, the first two who had a discussion wouldn't have been violating the statute. It's when the third brings it to a quorum that the violation occurs. And so if Counselor A is not part of that communication, if it's simply Counselor B is communicating with the other counselors, I don't know that I would see that as a violation for A, that I would see it as participation in the serial communication. But
Well, I
also,
appreciate that, but I need the rule to say that.
yeah. All right, I'll keep working on that.
Thank you. I
Matthew.
need to step away for just a minute.
Okay.
Yeah, I was just gonna, so I think maybe just add to Scott's point for in one, you can scroll up a little bit. So in the third line towards the end, it's shall not use the communications for the purpose of deliberating or deciding. So isn't there already a knowingly and intentional aspect of that there has to be the purpose for them to engage in that and those communications?
I had multiple discussions with DOJ about the knowing and intent thing and about adding things like used, like in the definition of intermediary, adding in used as a way of indicating that there is that sort of intentional act of using someone else. I don't know that it was my intent when I was tweaking this definition, this subsection, to use the term for the purpose of deliberating as a substitute for knowing and intentional. I didn't necessarily read it that way, but I think that I can see why you might. I kind of think about, is that something where that language needs to change, or where the concept that we were debating here with Scott could be addressed with that sort of language. Like when A and B were meeting and just discussing, was it for the purpose of deliberating or deciding? And it was only when B brought it to the other counselors that suddenly it is for that purpose. But worth thinking about. I will continue to ponder that issue. Chris Wright.
On the for the purpose, could that be results in deliberating or deciding on any matter versus the purpose? Because another counselor may call another one and not intentionally have the purpose, but just be sharing maybe information. But then maybe other people get pulled into it and it results in. But some of that may also be reflected by law in the matrix if it gets pulled into a hearing. They may have already accounted for that knowing versus intentional has to be teased out in a hearing. And that might be why we have minuses on that matrix.
No. I don't know that changing it from purpose to results in deliberation solves the sort of Scott scenario, in that even if the communications do result or, would at the end result in deliberations, I don't think that solves the what do we do about Counselor A issue.
Yeah, and I don't know if there's a section that is put in intentional versus unintentional. That goes into the matrix later on if it does end up coming to a hearing.
Yeah,
Anyway.
and that actually is not going to go into the matrix. So
yeah.
I don't think we can do the intentional, unintentional, knowing and intentional.
Yeah, to me that brings up a whole nother can of worms, so to speak, that in a hearing you end up kind of teasing out. It would be great if it could be teased out like that and people know their rights up front when they're in a meeting. And I don't think any of the counselors that I'm on commissions with are really aware of a lot of these. And so I personally am going to be going to our city manager and mayor and saying that everybody really needs to sit down and really look at this and have a big discussion, because we can really affect each other. And I'm thankful I actually came onto this board, because I really did not know a lot of I've read this and I had some different understandings, as we're now finding out here. So, thank you for doing all this, by the way. It's a wonderful opportunity to look into all of this. Definitely. I thank you.
Additional comments on this? I will definitely sort of continue seeing if I can find a way of addressing Scott's concerns in that scenario and the related scenarios, obviously, that could come up. Okay, why don't we take a short break and be back at 2:15? Okay.
little bit.
Oh man, I had to go get my fan.
No, you got pants on.
I do. We're no longer needed. Okay. My camera's back on, good. Hey, welcome back. We will proceed to the notice rule. Casey?
199-050-0040 notice requirements. Sub 1. Public notice reasonably calculated to give actual notice is required for all meetings of a governing body. The purpose of providing public notice is to give notice of the meeting details and subjects to members of the public at large, as well as to interested persons and media representatives who have requested notice. Sub 2, methods of notice. A, notice to the public. The governing body satisfies the public notice requirement in subsection 1 by providing notice of its meetings to be displayed conspicuously on the public body's or governing body's website. If the governing body does not maintain a publicly accessible website, the governing body shall satisfy the public notice requirements through other means, such as community postings, bulletin boards, newspaper notice, or
any other
means
right.
that provides actual notice to the general public. Sub B, notice to interested persons. A governing body satisfies the interested persons notice requirement in subsection 1 by providing notice through A, interested person lists, mailing lists, or other lists of persons or groups maintained by the governing body to provide notice or communication. B, social media platforms normally utilized by the governing body for communications. Or C, any other means to provide actual notice to interested persons known to the governing body. C, media notice. A governing body satisfies the media notice requirement in subsection 1 by providing notice to those media representatives who have requested notice, either in the method requested by the media representatives or by any other means reasonably calculated by the governing body to provide actual notice to the media representatives. D, state agencies shall also post meeting notices to the Oregon Transparency website. Other public bodies may post notices to the Oregon Transparency website. Sub 3, content of notice. The public notice shall identify A, the time, date, location of the meeting, and to the extent reasonably possible, the electronic link or telephone access information to allow members of the public to attend the meeting by telephone or electronic means. B, the agenda or list of the principal subjects anticipated to be considered at the meeting. The agenda or list of principal subjects shall be specific enough to permit members of the public to recognize the matters in which they are interested. The governing body may amend the agenda or may add or remove items from the list of principal subjects prior to or during a meeting. C, the name, telephone number, and email address of a person at the public body to contact to request an interpreter or other communication aids. As an alternative, the notice may indicate that the governing body will provide a sign language interpreter or other communication aids at the meeting. D, executive session notice. A, if a meeting is being held only to conduct an executive session, the notice shall comply with sections 3A through C, and the notice shall also identify the specific statutory provision authorizing the executive session. B, if an executive session is to be part of a regular, special, or emergency meeting, the notice shall comply with subsection A, or prior to entering the executive session, the presiding officer shall identify in open session the specific statutory provision authorizing the executive session. Sub 4, timing of notice. The public notice shall be issued in advance of the meeting in accordance with the following timelines. A, regular meeting. As much advance notice as reasonably possible, but no less than 48 hours advance notice. Providing notice of less than 48 hours is allowed if the meeting is held as a special meeting. B, special meeting, at least 24 hours advance notice. C, emergency meeting.
as much advance notice as reasonably possible given the emergency circumstances. An actual emergency must exist. A, the governing body shall make a finding as to the reason why the meeting could not be delayed to allow at least 24 hours notice, and the meeting minutes shall describe the actual emergency justifying less than 24 hours notice. B, the governing body shall attempt to contact the media and other interested persons to inform them of the emergency meeting by telephone, email, social media, or other method designed to provide actual notice. C, if reasonably possible under the emergency circumstances, the emergency meeting notice shall be conspicuously displayed on the governing body's or public body's website. If the public body or governing body does not maintain a publicly accessible website, the emergency meeting notice shall be conspicuously displayed on a notice board, such other manner as the governing body determines may provide actual notice of the emergency meeting to the public.
And obviously, Jennifer, this is one of the places where I was endeavoring to address the concerns that Sina raised. Probably a little clunky, but
Understood. I will point this out to her in my notes.
okay. Comments, questions, suggestions? I will fix the backwards words in subsection 2A. There's always something that gets past me improving. Matthew.
Under 4C, and then in A, governing body shall make a finding as to the reason, and then it shall be described in the minutes. So I don't recall seeing that in the statute that there must be a finding from the governing body, just that there must be the minutes must reflect the reason for or the justification for the emergency meeting, but not that an actual finding has to be provided by the governing body.
Okay, I will double check the language there. Other comments, suggestions?
So one other question. When you're talking about the websites and conspicuously displayed on the governing bodies or public bodies website, are you looking at the homepage of that website or the page where their meetings are located or some other location? Is there a general consensus, I guess, of because if it's I don't know what conspicuously displayed on the website means, if it's a certain page or where it typically would be for meetings.
Yeah, I mean, that term was not mine. I think what we're aiming at here is that the notice can't just be buried somewhere that no one's going to find it. But I don't know that calling it conspicuously displayed solves that problem, because that doesn't, I'm not trying to suggest we have to have the neon lights flashing saying, emergency meeting. So is there a better way? All right. Nancy.
For City of Umatilla, we don't post our stuff on our website. We have a third-party provider. Would that suffice? Like, we post all our meetings and all our minutes and everything by a third-party provider's website. It is hyperlinked on our website. Like, you click on it and it takes you right there and it looks like it's our website, but it's not actually our website.
Yeah. I mean, I don't see a problem with that. I have to think about, is the requirement if it's posted to the publicly facing website, even if it is being hosted by a third-party provider versus by your public body, what's important is that it's been posted to the publicly facing website.
That concerns me because technically it's two different websites, even though it looks like it's one website. It's not. So when it says on our body's website, I'm like, okay, well, we use a third-party provider as our agenda management software. So it's concerning that it's very specific to our body's website.
So the solution would be I mean, I already kind of don't like saying public bodies or governing bodies website. Maybe the solution is there to sort of nuance that language to accommodate not just a website for the public body or governing body or third-party hosting service or whatever, so that as long as it's posted to the website, that is where the public's going to see it.
Right. And I guess that's kind of where I'm getting at. Is there a way to broaden that definition? Because I can tell you city recorders, they'll use Granicus, iCompass, MuniCode. There's all these different third-party providers that we use to post our agendas and our minutes and our videos and our recordings. So I don't know how we would address that. Sorry.
Yeah,
Thank you.
this is Commissioner Wright. Same thing in Newburgh. We have Granicus, a secondary agenda site, et cetera, et cetera. So, same. Thank you for bringing that up.
Okay, I will look into it. Scott.
So I took a minute here to peruse the public notice statute, and I just don't think you need this, the notice section. That's generally, that statute's fairly prescribed, and I think you've actually gone, your requirements are actually quite a bit further than what is actually in the law. So I just don't think you have a legislative peg to hang this administrative code on.
Okay. I'll discuss that with DOJ. Therese?
This is kind of piggybacking on what Scott just said. You know, if you're going to keep a rule that describes the notice requirements, I would suggest that throughout this 0040 rule, every time you talk about actual notice, I would like to see the language from the statute reasonably calculated to provide actual notice. It looks like there's a couple times or a couple of instances in here where there's a mention of providing actual notice, but it doesn't have that, that language that I think is pretty key from the statute of reasonably calculated.
Okay. That I suspect is simply, as with the Hasina issue, kind of needing to go through and make sure the right language is in all the places. So I can see your point about adding in the reasonably calculated language.
Sure, and when I submit my feedback after the meeting, I'll point out any that I see.
Okay, I appreciate that. Anyone else? On to meeting public attendance.
Okay, 199-050-0050, public attendance, meeting locations. Sub 1, all meetings of a governing body other than executive sessions shall be open to the public. A, meetings may be held at locations as specified in ORS 192.6304. Sub B, meeting locations shall be accessible to persons with disabilities as specified in ORS 192.6305. And meetings may not be held at discriminatory locations as provided in ORS 192.6303. Sub 2, to the extent reasonably possible, the governing body shall: A, provide members of the general public an opportunity to access and attend meetings by telephone, video, or other electronic or virtual means. Sub B, for meetings held by telephone or other electronic means of communication, make available a place or an electronic means by which the public can listen to or view the meetings in real time. The place provided may be a place where no member of the governing body of the public body is present. Sub C, for executive sessions, if any person, including any member of the governing body, is attending the executive session by telephone, video, or other electronic means, provide members of the media the same attendance option. Sub 3, when public testimony is permitted, the governing body shall: A, allow oral testimony by telephone, video, or other electronic or virtual means if in-person oral testimony is allowed. And B, allow written testimony, including that submitted by electronic mail or other electronic means, if in-person written testimony is permitted. The governing body may require the written testimony be submitted sufficiently in advance of the meeting so that the governing body is able to consider the submitted testimony in a timely manner. Sub 4, the public meetings law does not provide the public the right to participate or to provide public testimony or public comment. In the absence of a statutory or other legal requirement to hear public testimony or comment on certain matters, a governing body may conduct a meeting without any public participation. Sub 5, unless otherwise provided by statute, charter, or other organic law of the governing body or public body, the presiding officer has inherent authority to keep order and to impose any reasonable restrictions necessary for the efficient and orderly conduct of a meeting. If public participation is to be part of the meeting, the presiding officer may regulate the order and length of appearances and limit appearances to presentations of relevant points.
Scott.
There are problems. More than a few.
Okay.
The one, I don't read in section 1, all meetings, or I'm sorry, to the extent reasonably possible in 2, doesn't appear to me to govern the piece about requiring audio visual or electronic testimony. That is not what the law says that was passed in 21. The law does not only requires that that also requires the Ethics Commission cannot enforce something that the law does not require us to do, and that's what this section does. So if you encounter a problem with the electronic testimony, and could you scroll, I'm sorry, could you scroll down a little bit?
Good.
Let's see. Yeah, so 3, I'm in 3. So when public testimony is permitted, the governing body shall allow oral testimony, blah, blah, blah. The statute actually requires us to do that to the extent possible, reasonably possible. And so what I've got right now are members who are being subjected to racial epithets, hate speech, obscene content, and you're giving them an opportunity to file a complaint when they get cut off. That's what I see this is doing, and that's not what the law says. The law only requires us to do that to the extent reasonably possible. So if you're having a technology problem, if you're having a issue with getting Zoom bombed, there's a very legitimate reason a public body is going to cut that off.
Thank you. That was our concern too. We've had issues where other cities have been Zoom bombed, and if we follow this, then that would mean that we would not have the capability to cut that person off to the extent where some cities had pornographic images being shown. Although that was not communication, right? But it was a video that was being shown to the public that had to be cut off.
No, and you're not it's not just cities and out there, state agencies that allow public comment are facing the same thing. I guess I will need to kind of double check the statute. Is it a matter of changing where I have the to the extent reasonably possible clause? And I need to double check where it is in the statute.
I'm not sure why you need this at all, if we have the statute.
Because it is somewhat buried in the statute, and I've already had at least one city come before me where they didn't realize it was there. And that may simply be an educational thing, but other question is, can I use that language between adding what is in sub 5 about the authority of the presiding officer to control? Can we use that in conjunction with what you're raising here about, to the extent reasonably possible, to address what Scott and I forget who was talking, Nancy, I think, they have described about what is going on in meetings. So I guess my question is, can we use this as an opportunity to create a solution to that? And Scott says no.
We have a solution in the statute, and that is the city council has the ability to determine reasonableness now. And if you want more, you need a bill.
I guess my question is, I need to pull up the statute. Where in the statute is it saying the city council that the governing body has that ability?
My dear friend Rob has his hand up. I bet he's got it pulled up or memorized.
It's 192.670 sub 3. And I actually sent you a kind of a rather lengthy, admittedly obnoxious, lengthy email about it some time ago, Susan, giving you the history of how that particular subsection came about. It arose originally from an executive order at the time of COVID that I helped craft. I'm in 100% agreement with Scott. one, I don't think you need this rule. Two, if you really want to do this rule, just parrot the statute.
Hey, Susan, your mic's cutting out a little bit because I can see your lips move, but we're not getting any audio.
Is it better now?
Yeah, I think you got to be closer to it.
Okay. We will continue to work on that. And I did see your email, Rob. Yeah, Chris, you had your hand up. Chris
Yes,
Wright.
in Chris Wright, in a planning commission training exercise, we were told if things got considerably violent inside the a meeting, we were to stop and just stop. Same thing with electronic videos. If somebody comes on and does the bombing, we're just supposed to stop and end the meeting without even adjourning, etc. They told us we can actually do that. So I'm not sure what the solve there is. Solution will be there, but I do agree that something, yes, does need to be in the statute. Or in this that correlates with the statute. Thank you.
Thank you, Chris. Other comments or suggestions? Matthew?
On 3B, when you're talking about the written testimony, submitted sufficiently in advance so that the governing body is able to consider the submitted testimony in a timely manner. That's language that mirrors or close to mirrors the statute. When you're considering sufficiently in advance, and we're talking about being considered by the governing body in a timely manner, what we've had questions presented to us is, what does that mean? Is that able to be presented written testimony during a meeting? Because some members of the board of the governing body may not consider their ability to have that considered in a timely manner. Is it the day of, the night before? So I get like that's what the language of the statute is. So it's just unclear as to what that means.
We say something, I mean, I think I could be wrong, but I think the intent of the statute is to leave that to the governing body's discretion. I mean, how much, obviously, I think providing materials, and we've had that happen with our commission where someone shows up at a meeting and wants the governing body to review a 5-page written submission right there. So, as I said, I think the intent of the statute was to leave it open for the governing bodies to proceed in accordance with what would be a sufficient amount of time to allow the members to review the written testimony. I don't know that I don't think that we can put in 24-hour in advance or something, but is that really the best solution? And maybe clarifying that it's up to the governing body.
Yeah, I mean, that's what I think, maybe not dictating what the time frame is, but yeah, if it's up to the discretion of the governing body, because every governing body is going to have their own rules that they need to abide by.
Yeah. Okay. Anything else? Therese?
I think we talked about this at a previous meeting, but I'm still not sure where the authority comes from for subsection, let's see, what is it, 2C, for executive sessions. If a member of the governing body is attending remotely, members of the media have to be provided the same attendance option.
Well. Right. That has been the written advice of the Ethics Commission on executive sessions law. And when I look at the AG opinion on media, all the varying lengthy opinion, it doesn't say that a governing body can require the media to attend in a manner different from everyone else. So the solution, I understand the concerns of school districts and cities where you might be having executive sessions dealing with very, private safety, etc. The solution is to have them in person or get a legislative fix. I mean, if the concern is all these bloggers and you don't know who they are or who's in the room with them, it may be something where you need that legislative fix. Rob.
So I'll sound like a broken record again, but I think the legislative fix would be on just the flip side. Because during those proceedings I described to you, those legislative work groups I described to you in my email, the media proposed essentially this rule that was just mentioned, and that was rejected by the legislators that were chairing that committee, and it never made it into the bill. So again, I'm suggesting you're going beyond the statute in this paragraph mentioned here, but in many of them that Scott's mentioned as well. I think if you just parrot 192.670, you'll be safe, but you may have an ethics opinion that says that, but that's contrary to the legislative history. And that just doesn't make sense. And I don't think you can point to a statute that says this, but that's just my take on it.
Scott, you had something to add?
Yeah, so all 241 of my members are home rule entities. And so why that's important is that barring a clear and unambiguous preemption that forecloses any ability of any legislative action that prohibits a city from making a decision or enacting their own ordinance, they have the authority to do so. And so there's no preemption on the ability of a local government to define media. And in point of fact, we did this through ordinance in cooperation with the Oregon Newspaper Publishers Association in 2009. I understand you've got a faulty DOJ opinion that doesn't analyze the lead cases on home rule. But you don't have, again, no legislative peg for this hat. It's we can do this. That's not DOJ probably needs to take another look at this and look at it through the Phoenix decision, but this is well beyond, this is outside your authority in the statute.
Anything else on 050? Okay, we'll move on to 055.
199-050-0055, public vote requirements. Sub 1, all official actions or decisions of a governing body shall be taken by public vote. 2, secret ballots are prohibited. 3, results of all votes shall be recorded, including the vote of each individual governing body member by name. For governing bodies with more than 25 members, the individual votes do not need to be recorded unless one member makes such a request. 4, if written ballots are used, the written ballot shall identify the individual governing body member by name and each governing body member's vote. The vote of each governing body member by name shall be announced during the meeting at which the vote occurred.
Rob,
Just a real quick note, it doesn't affect any of my current clients, but one of my previous clients would be affected by the last sentence in subsection 4 in the way they conduct business. I think any public body that has a lot of members of its governing body would be affected. I don't actually believe that last sentence is what's accurately reflected in the Attorney General's manual or in the Attorney General opinion upon which it relied from 1979. I think the requirement is that the vote must be announced, the results, not that you have to, let's say, the vote of each governing body member by name shall be announced. I'll just mention my previous client had 120 voting members, and to go through it would turn their 2-hour meetings into 12-hour nightmares, where 120 votes were announced rather than just put in the record as how everybody voted. So I just don't think that last sentence works for some of the bigger bodies.
I'm wondering if I need to incorporate the sort of over 25 body language from sub 3 into sub 4 as well.
You
And
could,
I think that
or you could just recite what the AG's manual says, which is a shorter sentence and gets to the same point without having to say each individual by name, because that would just be tedious that would just be headache inducing to me. I'm glad I don't represent that client anymore if I had to do this. So.
Gabe.
Thanks. I just wanted to briefly state that, well, in the city of Corvallis, we do some appointments by ballot, not secret ballot, of course, but by ballot, and the results are announced at the meeting, but we have in my 4 years on the council, we've not said each councilor's vote by name. So I was curious if there was, if that was something that we should have been doing, or is this a change in this rule to require us to say it? You know, it comes up in the minutes that you review. It shows what counselor voted in which way, but it's not necessarily announced at the meeting how each individual voted.
And realistically, what I was trying to do here was just sort of put into the rules how the AG manual presented it. And I recognize, Rob, that I may have not done so effectively, but Gabe, I think probably, yes, you were required to announce how the counselors voted.
Cool. Well, all those were 30 days ago or more, so we're good.
Yeah, I'm not opening cases right now.
And if I can just say, I just respectfully disagree with what Susan just said, because I think that's my primary point that I was making, is the AG's manual, I don't believe, does require that.
I just taking notes for a debate with the AG. I will look into that and get you a potentially better answer. Nancy.
So when just clarification here, when they're talking about shall be recorded, are they talking about the actual recording, the video or the audio recording, or the minutes?
It's one or the other, because you're only required to do one or the other.
So if it's reflected in the video or audio recording and not in the minutes, you're still covered, correct?
Presumably because you're not required, if you're doing video or audio recording, you're not required to maintain minutes.
Thank you.
Matthew, you still had your hand up.
Yeah, thank you. So a couple questions. In one, you have all official actions or decisions. And since actions is included in the definition of decisions, shouldn't that just be all decisions of a governing body shall take place by a public vote? And two, you talk about secret ballots. Do we want to mention proxies and absentee voting or anything of the sort? Because those are all referenced in the AG manual as well, not in the statutes. But then third, the discussion we were just having about the 25 members, maybe I'm just a little confused by that, because this is talking governing bodies with more than 25 members. The statute, as I see it, references public bodies consisting of 25 members. And then the AG manual also talks about governing bodies. So respectfully, I'm not the expert on that part of it and haven't looked into it. I'm sure there's other folks that have, but that just seemed confusing to me. And obviously it doesn't really make sense to have the exemption relating to public bodies of 25 members, since we're really talking about governing bodies here. But
Yeah. All right. We'll look into it. Anything else? Let's get 60 done then.
Okay, 199-050-0060, minutes or recordings required. Sub 1, for all of its meetings, including executive sessions, a governing body shall provide for either written minutes or audio, video, or digital recordings. Sub 2, the minutes do not need to be a verbatim transcript, and the recordings do not need to include a full recording of the meeting, except as otherwise provided by law. But they shall give a true reflection of the matters discussed at the meeting and the views of the participants, and shall include all of the information identified in ORS 192.650 sub 1. Sub 3, after the meeting, draft minutes or recordings of all meetings other than executive sessions shall be made available to the public in accordance with the requirements of the Public Records Law and the policies or procedures adopted by the public body.
Questions, comments?
Chris Wright, is there
Okay.
any time frame that they have to have that published by?
The
Within
time
30
frame is
days?
what? No, I'm not. The time frame is what's in the public records law, which is, depending
Oh, I
on
know
the
it's there.
circumstances, 10 to
Yeah.
15 days.
I'm like, I know it's there. Okay, but it's just somewhere else, but you're not gonna have it here. Okay. Thank you.
Because, I mean, the dilemma is that part of the public meetings law where it says within a reasonable time, I don't want for the Ethics Commission to be, it's where do you draw the line between what is public meetings law and what is public records law? And I don't want to stray over into the public records law side. So where the public meetings law says within a reasonable time, you must make these available, I'm simply going to construe that in accordance with what the public records law says, or what the public body's own policies say. Any other comments on 060? Okay, we'll take a short break. Let's just make it a 5-minute break with hopes that we might finish by 4. So come back at like 3:05. Okay. Welcome back. Thank you for short break. Making progress. We're up to 0065.
199.-0500065. State Board or Commission meetings held through telephone or electronic means, video and audio recordings. Sub 1, a state board or commission that meets through telephone or other electronic means shall record and promptly publish a recording of the meeting on a publicly accessible website or hosting service so that members of the public may, without charge, A, observe a recording of the meeting if it was conducted through video conference technology, or B, listen to a recording of the meeting if it was conducted through teleconference technology that did not include video capabilities. Sub 2, the requirements of subsection 1 do not apply to any portion of a meeting that was lawfully held in executive session. Sub 3, the requirements of subsection 1 apply to any state board or commission within the executive department and whose members are subject to Senate confirmation. Sub 4, the recording of the meeting shall remain accessible on the website or hosting service for no fewer than 30 days after the meeting.
Questions or comments? And I'll debate, I'd have to look through my notes, who was that pointed out, that they use a third-party hosting service for their notices and agendas. I will go through and see if maybe rephrasing the language in that rule to something more similar to this, publicly accessible website or hosting service, if that might solve your issue with the earlier one. Brenda, you had a comment.
Well, I guess I've never maybe noticed this before, but we have our meetings virtual and then I draft the minutes and I post the minutes. Now I've got to post the meeting, the recording as well.
This was a new law that passed last year, I think.
Okay, so this is part of the new law.
So, but it depends on are you with a state board or commission?
Okay, I guess that makes me out. Sorry.
Okay.
Okay.
Yeah.
Thank you.
Anyone else? Okay, we'll move on to 070.
199-050-0070 grievance process. Sub 1, the purpose of this rule is to clarify procedures regarding the requirements in ORS 192.705 for filing a written grievance with a public body alleging a violation by members of a governing body of provisions in public meetings law. Sub 2, the written grievance shall be submitted to the public body within 30 calendar days from the date of the meeting where the alleged violation occurred. The written grievance shall identify A, the governing body that allegedly violated the public meetings law. B, the date of the meeting where the alleged violation occurred. C, the specific facts and circumstances that the person asserts amount to a violation of the public meetings law. D, the date of the grievance. And E, the name and contact information of the person submitting the grievance. Sub 3, the public body shall accept grievances by mail, email, or other electronic submissions. A public body shall post on its website the person and contact information to whom a grievance may be submitted. In the absence of a designated person, a grievance may be submitted to the public body's chief administrator or to the chair of the governing body. If the public body does not maintain a publicly accessible website, the public body shall provide notice of the person and contact information to whom a grievance may be submitted in the same manner that it provides notice of its public meetings. Sub 4, the The public body's written response to the grievance shall be submitted to the person who made the grievance within 21 calendar days from the date the grievance was received by the public body and shall satisfy the other requirements in ORS 192.705 sub 2. Number 5. As required by ORS 192.705.3, at the same time the public body responds to a grievance, it shall submit a copy of the grievance and its response to the commission. The submission of the grievance and response to the commission can be made by mail or by email at the email address identified on the commission's website.
Questions or comments on the grievance process? Gabe?
Yeah, thank you. I want to say I wasn't able to attend the last two meetings, but I was very pleased that that the committee and that staff put in the having somebody designated, a designated person. That was a big ask of OAMR, that we identify somebody. And I note that it talks about the chief administrator or the chair governing the body. It doesn't say under 3 if someone can be handed a violation or sorry, a grievance. It says you can accept it by mail, email, or other electronic submissions. So would a city be able to deny someone at a meeting walking up and handing it to the mayor? That, I guess that's my question.
And I think the answer would be no, but I think I need to fix that in the rule. So yeah, I mean, if someone shows up at the city's, you know, main offices and physically hands something to the mayor, and the mayor is the designee, if it's a written grievance, I think it would probably satisfy. It wasn't my intent to prevent that. So
Okay.
I will fix that in the rule.
Thank you. And because one of our concerns was that was about the physical handing of something over, was that if somebody hands it to a utility billings clerk, they might not know
Right.
where to get it. So just making sure that when we say it can be handed to somebody, they would need to physically give it to the designee, not
Yes.
just anybody. Yeah. Thank you.
Yes. Nancy?
For subsection 4, when you talk about the grievance being submitted to the person who made the grievance within 21 calendar days, most of the time we will mail stuff out like within the 14-day limit, and then people will refuse to receive it at the post office. So what do we do in that case when you've asked for a receipt from the post office and they have refused their mail?
Well, you will have the documentation, especially assuming that you also satisfied sub 5, you'll have the documentation of sending it to them.
We've had that happen, you know, people deny their certified mail and
they do.
So as long as we
Okay.
can provide documentation to
Yeah.
your department, to your commission, we're good, correct?
Yeah, I mean, you have documentation that you sent it. So either that you sent it certified mail, or if it was by email, you have the email sent receipt. Some documentation that within the 21 days you sent it.
Yep.
Gabe, you had your hand up again?
Nope, sorry, just didn't lower it.
Oh, that's okay. Matthew?
In 1, talks about alleged violation by members of a governing body. Is it by members or just the governing body?
Could be one or both, and I think in 1, I mean, I've seen grievances that talk about specific members violating, especially if the grievances that allege sort of serial meeting or serial communications. But it may be here that just a violation by a governing body of the provisions would be sufficient. I'll figure that out.
And then under 3, when we talk about the public body shall accept grievances by mail, email, or other electronic submissions, are you saying that, or is this rule saying that the public body must accept by all of those methods, or that they are free to choose which method they want to receive grievances in?
I think they have to accept by all of them, and I would add in person in accordance with Gabe's earlier comments that a person submitting a grievance, if they're submitting it to the designated person, whoever the public body has designated to be the person to accept grievances, then it's a written grievance. Email is written. I'm not sure what other electronic submissions would be, but
Well, a web page submission. That's not going to a dedicated person. That's just going to the government or to the public body. So there's really no designated person for that. So, but if that's the way that the public body designates it wants to receive any grievances, so it's all going to a single location. You're saying that they must also then accept by mail, and they must designate another email address for it to go to.
they must
It just seems
they
like
accept it by mail? Yes.
Yeah, it just seems like if there are short timeframes on this, and you're having them look at all these various locations where these grievances may come in, instead of allowing these public bodies to designate how they want to receive these to make sure they're all coming in a consistent manner.
The dilemma of saying, I want it submitted via this website, this electronic filing system or whatever, is whether all members of the public have the ability to do so if they have a grievance. I don't think we can restrict it that far. So if, as Gabe said, someone wants to show up and they have a written grievance in their hands, and they have not submitted it through your online system, I think they can still, if there is the designated person, they can hand it over.
Okay.
Scott.
So the good news is I actually think you need this rule. Explaining how we deal with these complaints is actually very helpful. I do have an issue with that 3 on the electronic submissions, because the way I read that, you could get you could get a complaint as a comment to a comment on a Facebook post unrelated to any topic, and that would happen, and that would satisfy the requirement. That seems a little unreasonable. I think if you just want to spell out very clearly in a physical mail, physically handing it to or emailing a specific person or a specific designated email address at the public body, I think that makes it very, very clear.
Yeah.
And what our members will do is we'll get we have you can set that stuff so you get notifications so they know that they've gotten this complaint in. This is a little broad. I mean, And if you look at what happens on some of our members' Facebook and social media pages, this isn't, I would totally expect that scenario to occur on the regular.
And like I said, I'm not sure how electronic submissions got put in between me and DOJ, who knows? But I agree with you. I think the simpler we make it, the better. In terms of, I do want the public bodies to designate and
Sure.
if possible. Because I don't want, them handing it to just some person wearing a city logo and then the city's on the hook because it didn't make its way to the right person. So
And
I think let's play with just getting rid of the electronic submissions and say, shall accept grievances delivered in person or received by mail or email to the designated email address or something.
And then the other point I had was if the city finds the grievance unfounded, and that's done by the city attorney or the city manager or recorder or some other professional who's trained in this stuff, where does that go into when you get to the penalty phase? If a violation moves forward and the city has kicked it as unfounded and OGEC disagrees, where does that leave the council?
Looking at the matrix. I mean, there arguably would be complying with agency policy. The policy language there is a little awkward, but I will play with seeing if I think that's a valid point, Scott. I will play with seeing with how to address it either in the matrix or otherwise.
Thank you.
Nancy.
Going back to 3, what Scott was kind of talking about. So I come from a really small town in Eastern Oregon. Everybody knows that I am the city recorder. Is there a way that we can add that these would be filed during regular business hours? Because I don't want to be a Saturday soccer game with my daughter and somebody coming up and say, by the way, here's an official grievance for the city. We don't have the luxury of anonymity within our communities sometimes.
Yeah. I'll see if I can work that in.
Yeah, just to add another story there, our former city clerk here in the city of Albany, someone had an elections related complaint, drove 3 towns over to where she lived and threw rocks at her window until she came out on the weekend to sign a form that he thought had to be done that day. So yeah, these things happen and are not great.
Yeah. Gabe, did you have anything else or just that?
Just that.
Okay. Matthew.
So am I to understand that you're going to be looking at taking away the ability for submissions by electronic means?
Well, so when you're talking electronic submissions, what do you envision?
A public body has a web page on their city page, on their page that they've created that identifies what the grievance policy is, just like they'll have something for how to submit public comments. And so, or to make a public record request. And it goes in, they submit the information, that's everything that's required under 2. Otherwise, it wouldn't be a sufficient grievance. This way, if the individual has the ability to submit it there, it's all going through the same process. It's still going to go to either, one person or a team of people that will be able to see it. And I guess they can still accept grievances by mail or email, but I don't think we can limit if they decide that's how they want to do it. Again, it won't be every city, but some cities or districts or school boards or whatever may prefer that option.
Yeah. And I think that may have been why this got put in. I think maybe it just needs to clarify to avoid the problem of what someone earlier said of, the random, posting on Facebook claiming that was submission of a grievance or so.
Well, I guess it goes back to when we talked about the notice requirements and posting that on a governing bodies or public bodies website, this would be similar to that.
Yeah, and I can work on rephrasing this to better fit that. It's not that I want to eliminate the options for the cities or the governing bodies. Yeah. I will continue to play with that. I don't see a problem with a city having a submit complaint button on wherever.
Right. And if there is the second sentence there that you have to, the person and contact information, again, if you're concerned about individuals being harassed outside of, the office place, that gets rid of that. Kind of.
Except that as someone's already pointed out, in some of these really small towns.
Like I said, kind of. Not always, but.
All right, I'll keep working on that. Gabe, you had something more?
Yeah, I was just gonna add on to that. The City of Albany has through Laserfish a form that we take our public records requests in through that automatically emails it to anyone who works on the public records requests. So yeah, that is a way that's a solution we have for records requests that we probably would adapt for this too. So I just wanted to caution, if we're playing around with electronic submissions and the language, making sure that kind of stuff is still available for cities to use.
Yeah, I think that's the idea here, but it maybe I just need to clarify. Okay. Well, let's move on to 75.
199-0500075 complaints, dismissal for failure to satisfy ORS 192.685. Sub 1, the purpose of this rule is to clarify procedures regarding the opening of one or more preliminary reviews based on a complaint of violations of the public meetings law made against one or more members of a governing body. Sub 2, a complaint alleging violations of public meetings law that is filed with the commission under ORS 192.685 will be construed as a complaint against all members of the governing body, and cases will be opened for each member of the governing body. Sub 3, when a complaint involves the members of a governing body, the commission hearing of the governing body members' cases will be consolidated at the preliminary review phase and investigative phase, unless one or more members of the governing body object to the consolidation. At the conclusion of the preliminary review phase or investigative phase, the commission will make individual determinations regarding the cases of each member of the governing body. Sub 4, A complaint that is dismissed for failing to comply with the grievance requirements in ORS 192.685 is a procedural dismissal only. The dismissal does not prevent the commission from taking up the matter on the commission's own motion. The dismissal does not prohibit a new complaint from being considered based upon the same conduct alleged in the dismissed complaint, if the new complaint is based on a grievance that was timely submitted to the public body and that complied with these rules.
Comments or questions? Nancy?
Is there a time limit for responding to a dismissed case for procedural purposes only? So say that within 21 days, the city said you do not meet the requirements for this, we're going to dismiss it. Does the time clock start again for them to submit their grievance? Or are they still being held within those 30 days?
The 30 days is 30 days from when the alleged violation occurred. So what has happened and has happened already is people started September 23rd filing complaints. The initial complaints did not meet the prerequisites of the grievances. So basically what we're required to do is open a case and put it on the agenda for dismissal by the commission because it doesn't meet the requirements. Now, the person who filed the complaint gets notified, this is what is going to happen. You didn't meet the prerequisites. This will be put on the agenda for dismissal. If they're still in those 30 days, they could send in the grievance, wait the 21 days, and then file a new complaint with us.
But it maxes out at 30 days from the date of the grievance, correct? The time clock doesn't start again after 21 days, so they would have 7 calendar days.
The grievance time clock does not restart. The grievance time clock is limited to 30 days from the date of the violation.
Thank you.
Regardless of what we do. Chris Wright.
I think there needs to be a space between 3 and 4. That's it.
Yeah, I was having some formatting issues with this section. Microsoft Word and I weren't getting along.
Is it giving you a what for?
Susan, you cut out. Did you say my name? This is Teresa.
Yeah, sorry.
Okay. That's okay. I just wanted to suggest that you use the active voice in the last sentence of subsection 4. So rather than say the dismissal does not prohibit a new complaint from being considered, I would just suggest using clearer language to make it clear the commission can consider a new complaint.
Absolutely. My staff is laughing because I used to be an English professor and they love it when I'm caught violating my own rules.
That's great.
Anything else? Okay, we'll move on to 80.
199-050-0080, training requirements. Sub 1, all members of governing bodies are encouraged to comply with the minimum training requirements in section 2A through C of this rule. Sub 2, if a governing body has total expenditures of $1 million or more in a fiscal year as adjusted for inflation in the manner required by ORS 192.700, sub 3, each member of the governing body shall A, at least once during each term of office, attend or view a training on Oregon Public Meetings Law provided by the commission or approved by the commission in the manner described in OAR 199-005-0085. B, maintain a record of the training viewed or attended, including the date viewed or attended and the name of the provider of the training. And C, truthfully certify completion of the training upon request of the commission. Sub 3, a person who serves on multiple governing bodies, each of which require the mandatory training, may attend a single training to satisfy the requirements in section 2 of this rule, so long as that training occurs during each applicable term of office. Sub 4, exceptions. The training requirements in section 2 of this rule do not apply to A, members of a governing body if the governing body has total expenditures of less than $1 million in a fiscal year as adjusted for inflation, or B, members of governing bodies of state government.
Okay. One thing you may have noticed is changing the language in what is now sub 2. I still would love to see Hasina or someone get a legislative fix for the definition of public body in 192610. But I shifted how we phrased it. I didn't shift the intent of the training of who we are applying the training requirement to, but I shifted the phrasing. So it is if the governing body, basically a governing body that has expenditure authority, approves a budget for a public body, whatever, that is $1 million or more, with the idea that the training requirement applies to those governing bodies and not to the ad hoc committees and subcommittees and advisory committees and budget committees and etc. So hopefully this does a better job of making that clear who it applies to. Gabe.
Yeah, I have a few things. I want to start by asking about the word encouraged in subsection 1. I thought it was a requirement, and so the word encouraged to me is more like a suggestion. So I was wondering if that was intentional or the reasoning behind that, and then I have another thing after that.
The word encourage is actually in the statute, and the intent, and it may be that we rearrange this rule a little. The intent is that if you have expenditures of $1 million or more, you're required to. Everyone else, so the members of those budget committees or planning commissions or whatever, we really strongly encourage them to get trained as well. But that is not the requirement of the statute. They're simply encouraged to do so.
Okay, which leads to part 2. Again, I was gone for the last 2 meetings,
Mm-hmm.
but so is the current guidance under these new rules that members of advisory bodies to the governing body, for my instance, the planning commission to our city council, our planning commission would not be required by state law to take these trainings. Is that correct?
Does your planning commission have?
It does not have a budget, an operating budget, no.
Doesn't have an operating budget. They don't make decisions on budgets. They would not be required to take the training.
Okay, but
they would be encouraged to do so.
Yeah, fair. Our budget committee would, because they more or less oversee I mean, they don't have an operating budget, but they approve the budget of the city, or recommend the budget of the city.
But they don't approve. They recommend the budget to the city council. It would be the city council that is the governing body that has the expenditures.
Okay, so these are questions that our OAMR group has been asking Nancy and I for months, and so I'm glad to hear the final answers on those. Okay, I think that answered my question for now. Okay.
Chris, right?
In the event a planning commission does decisions on their own and recommendations to the governing body, is the planning commission not considered then?
This is
As long as you
the
don't have
training, the mandatory training requirement is tied to being a governing body with expenditures of
Government.
$1 million or more.
And the governing body is the head of everybody, the very
Well, no,
top
I
of the
mean,
tier.
as rule number 10 points out, a governing body, there are all sorts of, the planning commission is a governing body, the budget committee, the library district, well, you know, there are lots of governing bodies, but it is only the
But you
governing
have
body
to,
with the expenditure threshold that has to have the mandatory training.
so I guess it comes down to the same thing. Me as a planning commissioner and others, we need to inquire in our cities if we have budgets, first of all, I guess. But yeah.
I mean,
so some of them do.
most likely the answer is, and the intent of the statute was, city councilors, county commissioners, basically the elected officials, school board members, where they are the ultimate body that has that expenditure authority.
Okay. So it comes down to the elected. Okay. Thank you very much.
Mm-hmm. Gabe, you had something else?
Yeah, I have one more, sorry. This kind of segues into the next section, so if you want to take it then I'll understand. But those advisory groups, like let's just say our airport advisory group that doesn't have an operation budget of $1 million, we would like to have them, we would like them to take a public meetings training. Are we allowed to give our own training? Because they don't necessarily need to take the official training. Can we give our own training on our own timeline that is not necessarily approved by OGEC as in the next section would require our trainings to be? So I guess, yeah.
So obviously I think our preference would be for them to get trained by OGEC or SAO or LOC or whatever, one of the groups that's had the trainings approved, but the training approval process and really only applies to the training for those who are required by the statute to get the training. So if a public body that has a bunch of ad hoc committees wants to do its internal training for the members of those committees who would not be subject to the requirements, I mean, the more training they get, the better. Obviously, I would hope that it would be the correct, like, training. I wouldn't want a public body to be giving their ad hoc committee members the wrong information, but they're not required to get the training. So the training that we will approve under Rule 85, we're not going to go in and approve the training that your local public body is giving to its ad hoc members, unless it wants us.
Thank you. Yeah, we have an annual training that our city attorney puts on for our members. So that is helpful. Thank you.
Chris, did you have something more? Or you just forgot the hand? All right, Matthew.
So thanks for clarifying the mandatory and encourage language. And I'm wondering if under 3, that is really needed anymore. Because that's talking about, individuals that are serving on multiple governing bodies that are going to have total expenditures over $1 million.
So I have 3 in there because that was actually a specific request that we got in, where there are, not a lot, but there are people who are in fact sitting on multiple governing bodies that would be subject to the threshold. And they just wanted to make sure that they're not going to be required to get separate training. That if they do it, it will count for both.
Okay. So is it not necessarily governing bodies of the same public body?
Oh, yeah, no, they're on
Right.
different public bodies.
Okay.
Rob?
I was just going to give an example for Matthew. In county governance, sometimes county governing bodies take their hat off and put a different hat on for a different governmental entity. For example, at ORS Chapter 451, Countywide Service District. It's technically a different legal entity, and it would be kind of ridiculous to make people go through 2 or 3 or 4 or 5 trainings because they have 4 or 5 different hats.
I agree completely with you. So, but thanks for the additional info.
Okay, we'll move on to 85.
199-0500085, training delegation and approval process. Sub 1, the commission may delegate the preparation and presentation of public meetings law trainings required under ORS 192.700 to another organization. The training provided by an entity other than the commission does not satisfy the requirements of ORS 192.700 unless the commission has approved the content of the training prior to the presentation of the training. Sub 2, an organization seeking commission approval of its training shall submit a request using the form available on the commission's website no less than 30 days prior to the presentation of the training. The organization shall provide copies of all training resources applicable to the training presentation, such as slides, handouts, narratives, and recordings, to the commission for its review. Sub 3, the executive director will review the training content for accuracy to ensure that the training includes all substantive requirements of the public meetings law and best practices for ensuring compliance with the public meetings law. The commission will make available on its website the rubric by which the executive director will evaluate whether or not a training meets the requirements. Sub 4, if the training content meets the requirements to the satisfaction of the executive director shall approve the training program. A list of approved training programs shall be available on the commission's website so that any person may verify that the training has been approved. Sub 5, the commission's approval of an organization's training will expire 1 year from the date of approval. Organizations will need to resubmit their training or submit new training for approval annually.
Comments or questions? Nancy?
Are you wanting resubmission every year because the laws are going to be changing every year, or you're going to be updating these every year? What would be the reason to have to submit this annually?
One, the trainings people also change their trainings every year, often. And that to make sure that the laws and the rules, that the training is up to date with the laws and the rules.
So you think this will be modified every year?
The rules, not necessarily. I'm not doing this process again anytime soon. But the idea, the submission of the training, I mean, it hopefully will not be a difficult or long process. But if any time that suddenly how you're presenting the training, what explanations you're giving, in terms of executive session law or anything else, it's simply that information needs to be reviewed once a year just to make sure if it's all the same, it'll be an easy process.
And will you have a system in place that will inform the organization that they need to resubmit their training every year or annually?
Yes.
Thank you.
Chris?
Out of curiosity, I know well, 3, at the end of it, it does say the exec or the commission, but should the number 3 state the commission's executive director? If somebody's scanning, they may not pick up that last sentence and they might mistake it for executive director of their city. So should the committee's executive director will review the training, even though later on down the sentence you say the commission will make available, blah, blah, blah.
Okay, I'll clarify.
Thank you.
Okay, it's almost 4 o'clock, so while I was hoping to get through all of the rules, and we are very close to the end, but I don't think that's possible without keeping you guys late. So I will break it here, and next week we will finish up the executive session rules and the penalty matrix, address any additional changes I make to what we have reviewed, and hopefully have time to have the RAC review the fiscal impact statement and racial equity statements. Any comments or questions? Chris, you still have your hand up, please. Okay. All right, well, if there's nothing else, my staff will send out the survey. I would encourage you to submit any questions. If you find any more passive voice, send it my way. And I will get to work on addressing some of the things you've issued, the points you've raised. All right, thank you both. Thank you all so much.
Thank you.
Thank you. Thanks, Susan.
Thanks, Susan. Thanks, Casey.
Bye, thank you.
Thank you, everyone.